only for this particular
Only for
class.
this group. Yeah.
Okay.
And
Yeah.
that should not be
Only.
listed or recorded in live stream anywhere. Yeah. Okay.
Sure.
Thank you very much. It was a very useful presentation, Sarah. And a quick question, without mentioning the name of who has raised this question, how much is much for children's education after giving them basic degree? Should I continue to support them for the degree in USA or private university? I think I'll take this question instead of Sarah because I've been a banker and I have sanctioned so many loans and disbursed so much of loans. Whenever I sanction a loans or disburse any loan, the first thing I do is call the student who's going there. I tell them, look, your dad or your mom is a co-borrower. The primary responsibility for paying back the money is you, gentleman, or the lady.
Correct.
And most of the loans have been paid back by the participant, by the student. It is advisable to make this very clear that the responsibility to repay the money is that of the student. It would be your best child, your best daughter, best son. Make them responsible. Only when they are responsible will they be accountable to pay back the money. That is what I would say in short. Right?
I can also add
Next,
to this.
yeah.
Actually, if you go and have a loan done, it induces the discipline from the first salary that your son or daughter will take.
Sure.
And the money left after your life, after all, they are going to enjoy. So you can definitely have a loan done and they can, as Murali said, they can repay the loan.
Yeah. Thank you very much. You also covered a little bit on living will. Regarding living will, we'll have a separate session after talking to Mr. Abhijit, because that's a very vast topic. Now, the Supreme Court has already cleared the laws concerning living will, and that cannot be done in half an hour. That takes at least 1 hour session. We will handle that living will separately. Thank you very much for laying an outline on that. Next question is, what is the process of creating a trust? This is for you, Sarah.
Yeah. See, first and foremost, a trust deed needs to be done, and definitely you will need experts or domain expert engagement. So you will have to engage with the domain expert, and if required, we can also be of help. A trust deed has the details of what you want to control through the trust. The trust, you will have to define who are the beneficiaries and what sort of a benefit you want them to enjoy. And the trustee also to be named, and the trustee will play a very critical role. So you should not be naming someone who is not going to act in your family interest even after 10 years, 15 years. So selection of a trustee becomes very important. The moment you have decided on trustee and the beneficiaries, you can contact any of the domain expert and we'll be able to draft your trust deed. And the trust deed drafted will have to be registered. Then you can apply a PAN in the name of the trust, and it's a separate income tax file. All that will follow. The first thing is to contact the domain expert and bring up your trust deed and decide on your trustee.
Next question. Thank you, sir. I had planned to make a will. I am told in Goa that my husband should also approve of my will. Is this true?
Goan laws, I will have to come back. This is Goan law is, I'm getting some help. It will be a Portuguese civil code. Here in Goa, Portuguese civil code is what will apply.
Can we deal with that offline?
It will be dealt as per the Portuguese civil code. So I will need some time to get through that.
Okay. Next question. Because of want of time, I'm rushing a little faster. When is the right time to make a will? And if any complications develops, can the will be revoked or modified? Okay. That's the question.
Okay. See, the right time to write a will is the moment you have your asset. The first asset you buy, then you are supposed to leave a will. So will can be edited, altered, changed any number of times during your lifetime. And the last will, whichever will dates the last, that becomes a valid will. So will can be changed a number of times. I am sure the mind share what you had preparing a will may change in due course of the time. With that, you can definitely rewrite the will, and the last will becomes the valid will.
Yeah, correct. So it is the last will come into vogue. Yeah. How is the joint, next question, sir. How is the joint ownership estate can be addressed in the will when one of the person is still alive?
Okay. See, the joint ownership itself defines the proportion of ownership. If it is only said as joint, it is taken as 50% each. So the will writer, the author of the will be entitled to will away 50% of the property. So as a joint owner, you have right 50% of the right of the property. So you can only will away 50% of the right of the property.
Okay. Right. Next question is, can I make a conditional will? For example, if my both children are alive, 50-50, otherwise 100% will go to the living child or 50% will go to the grandchildren or, so that kind of a thing.
Yeah.
Is it possible
See,
to do?
these will be dealt by your domain expert. When we have the questions asked before drafting a will, these are the questions. If your sons were to predecease you, whom should the assets be going to? If one of your son predeceases, what should be the proportion of the second son? All this will be dealt in the questionnaire your domain expert will discuss with you. And all this will be part of the will if a specialist is drafting it.
Yeah. Next question, very interesting question. I'm alive still, I make a will. Then after some time I die. Can my wife alter that will? That's the question.
Not possible, sir. The moment a will is made, registered, that can never be changed. If the person is not there, one's lifetime, you can make a number of changes. The moment he passes away, the will becomes something carved on stone, not
Hmm.
possible to change.
Right. I have taken almost all the
So
questions here
there is
except for
one
one
more
question.
there
Yeah,
is
one
one more
question.
part where it
Please go ahead.
says to the same question that was asked, do husband and wife need to make separate wills? So, Saravanan sir's screen has frozen over.
Sarah, நீங்க மியூட் ஆயிட்டீங்க.
Oh
You're
yeah,
muted.
yeah. So do husband and wife need to make separate will? That is part of the question.
Yeah.
Okay, sir, there is two different way of addressing this problem. We also technically have something called mirror will. Husband writes everything in favor of wife, and wife writes everything in favor of husband. This is called mirror will. This will be applicable when both their interests are aligned perfectly in passing on the assets to the other. But what we would always encourage is you may have certain wishes which are away from your husband's wish also. Maybe you want to pass on something to your sister's daughter, which is not your husband's wish. So it is always better to have a separate will by a husband and wife, which can clearly express the wishes of each individual. But
Okay,
Yeah.
technically possible, we can have a mirror will.
right. One more question I've got. Is it mandatory to have the living will registered? Can it be on a simple piece of paper?
Yeah. See, will or living will, both you can have it on a simple piece of paper. Handwritten is okay. But living in a country of disputes. We are living in a country of contesting. So let me take an example of a will. If you have written a will and there could be a person who wants to challenge that will itself, if it is a simple piece of paper written, the contestant will say, this is not the handwriting of Mr. Karthik. Then you will have to have a number of documents to prove that it is the handwriting of Karthik. He may
Yeah.
say, Karthik, for a known time period, for 6 years, he was insane. But the will dated is 2 years before. So he was not in a capacity to write a will. So this will itself is void. How do you go and prove it? So
Yeah.
that's why we say, even if it is not mandatory to register a will, when you register a will, you go to the register office, sub-register sees you in person, he puts a stamp on the document and signs as a witness to the will being registered. So this will stand the court of law than a simple piece of paper. So if you want to put a defense against any of the contest which can crop up after your life, registering a will becomes very, very important. Same is the case with living will also, because the medical directive you give, people can say, somebody can challenge that medical directive saying that this was not the living will by the person. He was incapacitated even before the time the will is dated. So how do you go and prove that no, he was hale and healthy? So all these things can be overcome if someone is registering the will in the register office.
Right. Yeah, Brother Murli, can you read the questions?
Yeah, the next question is, my children are abroad. How will they inherit the property or the assets? What's the best way to go about that inheritance, transfer of
Yeah.
property?
No, this advice would be unpopular advice, but I will make the advice. See, with respect to inheriting, they can definitely inherit all your properties, but for the farming land. Cultivable land, NRI will not be able to inherit it. You will have to sell it. They will have to sell it, and they will have to take the financial assets. Other than that, any property that you have, they will be able to inherit it. And they will be able to take the money to their country of domicile, country of stay. That is not a problem. Only thing is, there are some procedures, like if you are leaving a house, they may have to take the no objection certificate or no due certificate from an auditor if they want to take the proceeds to the country of stay. So
Thank you.
procedures are there. We can easily take your children living abroad can handle it very easily.
So I think this will be the second last question. What's the cost of registration of will in Mumbai? Specific question in Mumbai. You may not know this. I think
Mumbai, you'll
uh,
have to take some
I'll
advice.
yeah,
Yeah, I'll
I'll
tell
take
you,
that.
the registration cost would be very minimal,
Uh,
but the cost of registering it, the other cost of registering it at register office could be little more. The payment that you have to make, our country is a country of payments, other payments. So some expenses on the registration day, you will have to take care of it.
yeah. Okay.
There was one question, right, Brother Murli? Okay, I think there's one which has just come. Okay, how to know if it's agricultural land? Somebody has sent me that.
So today, even we have drone-based mapping, which clearly says which part of the property is agricultural land, which part of the property is barren land. So somebody who has shown the agricultural land as barren land and claimed some tax benefit has been given notice because they had a drone mapping saying that these areas cultivable land, and they had photographs of cultivation being done. So nowadays it is very difficult to unduly take advantage of stating differently. If that is a cultivable land, you will have to state it as a cultivable.
Thank you. This is already 107. We'll just conclude this in another 3 minutes. We are already exceeding the
Yeah,
time, 7 minutes.
we
Uh, One question is here. I think this is an important question. Can changing of citizenship make the will null and void, or does it still valid? For example, my daughter, for example, she's in Australia. She was an Indian citizen. Now she got a citizenship of Australia. I have made a will already. How is it applicable? Does the
See,
will become null?
with respect to bequeathing the will assets, see, you are willing away to somebody domicile in Australia. It does not change any equation. They will have to probably make a visit to the country and get all the titles transferred with the will. That is only legal process they have to follow, and because they have changed their citizenship, it does not take away the right that you have given to them.
right, right. I think there was one question that we probably skipped earlier.
Yes, sir.
Uh, uh, it was about apart from willfully giving up own share, any other way to resolve property dispute? Like, I mean, what would be? I think it is basically
Amicable.
asked from a
See,
Christian position.
amicably, see, will is something we call it testamentary or after your life. Suppose if you feel leaving a will may not be the right solution to your family members, You can even undertake something called settlement. During your lifetime, you can settle your properties among your family members. You can go in for a settlement deed or a gift deed and distribute your properties.
Yeah.
Okay.
At the cost of repetition, at the close of this wonderful session that we had, it was my friend Biju in the church who recommended Sarah to me some 4 years ago. Yes, and let me confess that being a banker, put in 38 years of service, I thought bank deposits are the safe and the best. Actually speaking, they were giving me a negative return. If it was not for Sarah to handhold me and invest this money, I would have been in the negative growth in terms of the benefit that I got from the retirement benefits in the bank. Full marks to Sarah and his team to handhold
Thank
me.
you so
And
much for your
all of
kind
us on
words.
the call here, yeah, all of us on the call here, a very strong, urgent reminder, do an equitable justification of your funds so that you may be able to eat the fruits of your investment yourself before we leave this place in this country, right? So that's my sincere suggestion. So we can always have another session if need be. Number one. Number two is we also will have a session separately on living will, wherein we can invite Smriti Rana from where is it, Pallium India, who
Valuable.
has got extensive knowledge, and she is now
On
part
living.
of the World Health Organization as well. I had a discussion this morning, so we will have the opportunity to have her here with us to address on the living will.
Okay.
And these are all the questions that we have. Maybe there are more questions, but the limitation of time, it's already 1:11.
Yeah.
Over to Mr. Abhijit.
Correct, correct. I think people are still asking for the recording and to connect with Saravanan sir. Maybe you could put his number once again. Saravanan sir should have a Instagram page for followers. Yeah. Anyway, but thank you so much. Really, this is a
Thank you.
great session, and I feel even the Q&A was very nice. None of the names were mentioned. We have not. You are not on display also in this recording. Only those with open windows will be shown. None of the questions will be seen.
Yeah,
None of the names will be displayed. So if you give permission, I can put it on public mode later. But in case
later.
anybody has any problems, we will not do it. It will be on unlisted mode till that